Good morning, everyone. Welcome to Bardia Perry. I'd like to commence by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of this land, and I pay my respects to their elders past, present, and into the future. And I recognise their continuing connection to the land, waters and culture. And I particularly extend my respect to Aboriginal and Torres Strait Islander people here today, and also people who are watching this session remotely from their office or their home or whatever other location. Welcome, everyone. We're really excited to kick off our seminar program for workers' compensation this year. It is the most exciting time, I think, in years in the area of workers' comp. The reforms that we're talking about, which my colleague Maddie Chaplin and I have been watching like a hawk now for about 6 months, are perhaps generational reforms. Once every few decades in this field of work, there are reforms of this significance. For me, that is exciting. For me, it also, well, for us, it gives us a lot of content to talk about and to share with our trusted and valued clients, which we love doing. I would like you to think about today's presentation as an entree, because there's much more to come in all of this. And I would like you, and I warmly invite all of you here today and people watching remotely to come with us on this journey, because we're just scratching the surface today. And there's going to be a lot more to come from the government and the regulator on all of this. The topics for discussion today, and we're going to try and keep it to 1 hour. And I would ask if you wouldn't mind keeping questions until the end so we can keep the flow going, but we're happy to answer questions, and we're happy to hang around with you at the end to talk about these things if you have time. So the topics are on the slide today. We'll talk about where the reforms are at. Maddie will talk to you about the definitions, which are critical to the changes, and the 11A defence. And then I'll talk about the claims and dispute procedure that is going to apply in the area of psychological injury. So I stress today's discussion is about psychological injury, limited to that. There are other reforms in the legislative package, and we will deal with those at upcoming sessions of this nature. For the people listening and watching remotely, feel free to put questions in the chat, and Anna and Charlotte will look at those and pass them on at the end of the session, and we'll try to answer those questions. As always, feel free to contact anyone in our team at Bardia Perry at any time to talk about these changes. So what we have to begin with are 2 acts which have been passed by the Parliament of New South Wales. The first one I'll refer to as the Amendment Act. That was passed in November and has been assented to. And some of that act starts on proclamation. And so we don't have the proclamation yet. But look, if you want a ballpark commencement date for all of this or most of this, think about 1 July 2026. Okay. The second act, which I will refer to as the Modernisation Act, that's how the Minister described it all the way through the debates. It was passed last week. So we're still coming to terms with the content of that act, and it's awaiting assent. But again, think about 1 July as the start date for most of this. The government and the regulator, the State Insurance Regulatory Authority, CIRA, are working on regulations to operationalise all of this and guidelines. And that's where there will be, you know, the devil in the detail, as people say. So that's why I'm suggesting to you that this is an entree. I'll hand over to Maddie. This first slide is perhaps the most important slide of the day.
Hello, everyone. For those who don't know me, my name is Maddie. I'm a senior associate here at Bardia Perry. So as you guys may know, there has been an overhaul of the scheme when it comes to primary psychological injuries. But before I dive into those definitions and precisely what that means, I thought it'd be helpful to first talk about the changes to entitlements. Now, these were, I guess, clarified in the bill that came out last week. So like Mick said, we're still grappling with those, but it's a good place to start. So first, I want to point out what's not on here, and that is permanent impairment. So our next session is going to dive into the change to that process, but it is important to know that despite all this upheaval, the thresholds to claim permanent impairment are not changed. They're not mentioned in these acts. Back to the slides. So for weekly payments for primary psychological injuries, the starting point is that there is an entitlement only to 130 weeks in the amended section 38. Then for psychological injuries claims notified or made on or after the following dates, it can be extended to 182 weeks, so 3.5 years, if you satisfy the required impairment. And that is in the new sections 39A and 39B. So those dates are, so from 1 July 2026, at least 21% WPI, but less than 25% WPI. From 1 July 2027, it will be more than 26% WPI. And then from 1 July 2029, it will be at least 28% WPI. Now, these sections won't apply to a worker with highest needs. So if you have more than 30%. And it's important that after 130 weeks, for a primary psychological injury, they're only going to receive 60% of POE. So that's quite a reduction from what we're used to. Then for medical expenses, that is limited to a period of 1 year from cessation of weekly payments, unless they're a worker with highest needs. And then for work injury damages, again, for injuries notified on or after these dates, the threshold has increased. So 1 July 2026, it'll be at least 25% WPI. 1 July 2027, more than 26% WPI. And from 1 July 2029, at least 28% WPI. So for all of these changes, what I've been able to discern from the Modernisation Act is they're only going to apply for claims for injury notified or made on those dates. If that interpretation is correct, it means we may avoid an influx of damages claims being made in the lead up to 1 July because those injuries have already been notified, so the prior threshold should theoretically remain. So it's only injuries notified and claimed on or after 1 July 2026 that will face the higher thresholds in that staggering way. So by the time we see 130 weeks actually come around, and then the damages claims that if they follow the same timeframe, will probably be well into 2029 by the time we're dealing with the first claims kind of encountering 130 weeks and damages. But now, lurking at the bottom of this slide is a very important section, which has made its way into the latest Act, and I want you all to know it. And that is the new Section 280A of the 1987 Act. Now, this provides that the regulations can amend the Act to decrease the permanent impairment thresholds required for weekly comp, medical expenses, and damages. There are some prerequisites before that can happen, mainly a recommendation from the Minister and Treasurer that is in the public interest. But for those of you who are around after the 2012 amendments, if these threshold increases are seen as too harsh, I think we can expect to see Parliament wind them back. Interestingly, Section 280A2 prevents the increase of those thresholds. So they can go down, they can't go up. Now that I've given you that overview, let's jump into what is actually meant by primary psychological injury. Now, Section 11A3 of the 1987 Act, which previously provided the definition of psychological injury, has been repealed and replaced by the new Section 8D. Now, This definition says, in this act, psychological injury means an injury that is a mental or psychiatric disorder that causes behavioural, cognitive, or psychological dysfunction. Rather plainly, it's defined in Section 8C as not being a secondary psychological injury. And these provisions will apply only to the primary psychological injuries first notified to the employer on or after the commencement of the amendments. Otherwise, the existing provisions will continue to apply. So in terms of causation, compensation is now only payable for a primary psychological injury under Section 8.0 if three things occur. First, a relevant event or a series of relevant events caused the primary psychological injury. Second, there is a real and direct connection between the relevant event or events and the worker's employment. And the last one, employment is the main contributing factor to the primary psychological injury. Now, Section 4, so that deals with frank injury and the disease provisions, that will still apply, but in conjunction with this Section 8.0. But Section 9A does not apply to a primary psychological injury. So working backwards from that criteria, so the requirement for employment to be the main contributing factor, that's how we know it in the disease provisions, so that won't change. Then we have the additional change to the causation test of real and direct connection. Now it's similar to what we had in real and substantial connection for journey claims, but because it says real and direct, it's likely to be more of a strict or stringent test that has a stronger connection to employment. It's going to be an emerging area of development, but in most cases, we'll probably see it readily established. Coming back to the main point, so one of the key factors to determine eligibility will be whether it was caused, primary psychological injury was caused by a relevant event. So the definition of a relevant event is crucial. So from an overview point, there are 8 defined relevant events plus another event prescribed by the regulations. So that could expand. But I want you to think about, and Mick and I have share this view, but think about these 8 events as adopting 2 general categories. So thankfully there are 4 in each, which makes it a bit easier. The first category you can think about as events consisting of violence, trauma, criminal conduct, usually outside the workplace a lot of times, but also outside the control of the employer in most cases. And then the second category is more conduct-based, perpetrated against the worker, often in the workplace, but doesn't have to be, by the employer, co-workers, and others. So going to this first category, and like I said, there are 4 of them. I'll list them out for you. So A is being subjected to an act of violence or a threat of violence.
Thanks so much.
B is being subjected to indictable criminal conduct. C is witnessing a traumatic incident happen or a dead or seriously injured person at the scene of a traumatic incident. And D is experiencing vicarious trauma. These have definitions. They're in the new sections 3, 8J and 8K. So I'll just briefly go through them for you. Act of violence has the same meaning as the Victims' Rights and Support Act, which is acts committed maybe by one or more persons in the commission of an offence and results in injury or death to the victim. Indictable criminal conduct means the commission of an indictable offence and includes conduct of a person that would be an indictable offence even if it weren't for other factors such as mental illness or age or something like that. Meaning of traumatic incident means any of the following incidents if the incident results in or is likely to result in the death of or serious injury to a person from an act of violence, indictable criminal conduct, natural disaster, fire or explosion, motor accident or other accident, suicide or attempted suicide, or another incident prescribed by the regulations. Coming down to section 8G D. So we've got section 8K has the meaning of vicarious trauma, and that means the psychological impact of repeated exposure in the course of a worker's duties to the traumatic experiences of others that result from traumatic incidents. Certain occupations are more likely to be exposed to those sorts of events than others. First ones that comes to mind are those that interact with the general public or have a greater likelihood of being exposed to accidents or things of that nature. So thinking nurses, security officers, council rangers, people who are out in the day-to-day. Now, the second category, so those more relating to conduct, interpersonal issues, difficulties in the workplace, have irrelevant events E to H, and these consist of being subjected to sexual harassment, racial harassment, bullying, or excessive work demands. These also have their own definitions. Again, I'll take you through those. So I'll start with bullying. So that's section 8A. That means bullying means an individual or group of individuals repeatedly behaving unreasonably towards a worker or a group of workers in which the worker is a member. Racial harassment means an act that is reasonably likely in all the circumstances to offend, insult, humiliate, or intimidate the worker, and is done because of the race, colour, or national or ethnic origin of the worker. Sexual harassment means, in relation to a worker, means a person who makes an unwelcome sexual advance or an unwelcome request for sexual favours to the worker or engages in other unwelcome conduct of a sexual nature in relation to the worker. Now, then we get to excessive work demands. This has a bit of a longer definition. Again, I'll take you through it. I do recommend reading it yourself, but it's quite lengthy. But to start, excessive work demands means work demands that are three things: beyond the requirements expected of the worker's role, repeated or persistent, and not reasonable in all the circumstances. Section 8M then lists a number of matters which can be considered in determining whether work demands made of the worker constitute excessive work demands. And that says you can consider usual patterns of work, supervision, the nature of their role and level of responsibility, whether they can receive overtime or compensation for working additional hours, the needs of the workplace, staffing levels, industrial agreements, and any other relevant matter prescribed by the regulations. We'll see a few more, maybe. Looking at these events, I think we'll probably see a lot of excessive work demands come through, as well as bullying. Similar to what we currently see of bullying and harassment being listed on certificates without any other explanation. Overwork, heavy workload, things, we see that all the time. The definition of bullying, it's fairly broad. It may be able to be established in some cases where no objective bullying took place. And the definition of unreasonably, well, it remains to be seen how that will be defined, but it will probably be an emerging area in the Commission. For excessive work demands, again, it's quite a broad definition and it can be expanded, but it does bring into a test of reasonableness in all the circumstances. Again, that will be another area of development, but as we know from the current reasonableness test in 11A, can be particularly difficult. And this one does say in all the circumstances. So how this will apply and is interpreted by the Commission remains to be seen. Now, for that second category, so bullying, excessive work demands, racial harassment, sexual harassment, there is an objective test required to determine whether that act or omission has actually occurred. Now, in this test, and that's in 8L, it provides that an objective test must be used and the worker's perception of the relevant event is relevant, but only to the extent the worker's perception is reasonable. And the last one is consideration must be given to matters prescribed by the regulations. So again, hopefully we'll see some regulations come out to assist in this. But what we can see from this new section is the worker's perception of the event, which previously allowed them to establish injury on the basis of their subjective perception of what occurred, as long as those events were real events, is now only relevant to the extent that it is reasonable. But at the same time, it's quite disjunctive because objectivity, which is the objective test must be used, and perception are at odds. So the reasonableness of a worker's perception and balancing this is probably going to be an exercise that will be tested in the Personal Injury Commission, and we'll see how that works out. In any event, all of these tests and criteria will apply and they must be discharged by the worker on the balance of probabilities before they can proceed to be entitled to compensation, and before the 11A defence potentially applies. Speaking of, 11A, as we know it will be repealed and replaced with a new version. As you may know, the old version required psychological injury to be wholly or predominantly caused by reasonable action taken or proposed to be taken with a number of defined and limited categories. The new Section 11A replaces this and says no compensation is payable under this Act in relation to a psychological injury if the significant cause of the psychological injury was, again, three things: reasonable management action taken or proposed to be taken by an employer in relation to a worker; two, a worker's expectation of reasonable management action being taken in relation to the worker; and C, the last one, a worker's perception of reasonable management action taken or being taken in relation to the worker. This can, and although I failed to see how, applies to a primary psychological injury as well as a secondary psychological injury. It remains a disentitling provision, so responsibility still will rest with the employer to establish the defence, and will need to prove on the balance of probabilities that reasonable management action or the worker's expectation or perception of that reasonable management action was a significant cause of the injury. What constitutes a significant cause will be an area of development in the Commission. At this stage, it could be a slightly lower test than what was in the prior version of the legislation before the amendments last week, which was predominant cause, because the dictionary meaning of the word could infer perhaps a slightly lower threshold. But with that said, I do think there's actually a good chance the significant cause test will be similar to the predominant cause test, which was kind of interpreted to mean mainly or principally caused. So what does the reasonable management action apply to? The definition of reasonable management action and the expanded categories of employer actions to which the defence now applies are set out in the new Section 8F, which should be read in conjunction with 11A. Now, the starting point of 8F is that reasonable management action means management action taken in a reasonable way, and that is reasonable in all the circumstances. Then, if we look at Section 8F2, that gives you a list of things that can be included in reasonable management action. This is non-exhaustive, and it can be added to or, I guess, amended by the regulations. But to give you an overview, it can include appraisal, counselling of the worker, demotion, disciplinary action, dismissal. And a new interesting one is investigation into the worker's employer, by the worker's employer, of alleged misconduct by the worker or of another person relating in the workforce which the worker was involved. It can include promotion, leave, benefits, reclassification of their position, training, transfer, or communication with any of the actions mentioned in that section. While many of these were in the old Section 11A, there are some expansions that I've pointed out to you. Again, this interestingly, it does include the investigation component, but there's also informal appraisal, whereas previously performance appraisal was quite strict in its scope. But the last issue for establishing 11A then is that they need to prove that the action was taken in a reasonable way and reasonable in all the circumstances. Again, that may need to change the definition of reasonableness, but as I mentioned before in the other section, so in all the circumstances, that is going to give a lot of discretion to the members of the Personal Injury Commission. Because it says taken in a reasonable way and reasonable in all the circumstances, I think it will make it quite difficult for the employer to establish the action was reasonable. For example, and kind of how they do now with whole or predominant cause and then reasonableness, the Commission might find that, well, the action was taken in a reasonable way, but it wasn't reasonable in all the circumstances, or vice versa. And all the circumstances is quite broad and can include a whole host of things. The last comment I want to make in relation to the 11A defence is that in practice, it's really not clear how it's ever going to come into play. Perhaps there may be an avenue to bring it up in proceedings in the Industrial Relations Commission, which Mick will talk about shortly, to kind of provide an alternate narrative of the injury. But when we're dealing with the initial claim eligibility stage, as I've talked about, we have 8 relevant events. Not a single one of those is the conduct listed in reasonable management action. Reasonable management action is not one of the relevant events. So in order to establish injury and claim an entitlement, we have the relevant events. You have to establish the injury was objectively caused by one of those events. How then can we turn around and say, if we've accepted the injury or are in that initial stage, no, the injury, that there is an entitlement, can't have the entitlement because it was caused by something else. It just won't get to that point. And I think that brings me to a close. So I'll pass you over to Mick to talk about the new claims process.
Thanks very much, Maddie. That was great. There was a lot of reasonableness in all of that. Good lawyer words. All right. So Maddie has set the scene. There are 2 broad categories of primary psych injury. The psych injury born out of violence, trauma, criminality, matters of that nature. And then there's the psych injury born out of interpersonal conduct, performance, conduct and disciplinary issues, where there are 2 narratives, where usually you see the narrative of the employer trying to manage performance and conduct, opposed to the narrative of the worker, which is a narrative of unfairness. It's this second category that I'd like to direct our attention to in today's talk. The first category, violence, trauma, criminality, the claims process remains the same. So claims, injuries are notified, provisional liability is dealt with, claims can be disputed, disputes can be reviewed, and those disputes will go through to the Personal Injury Commission. So let's park those and let's talk about the conduct, performance type of claims. And this is where there's a new claims process. There are new provisions relating to disputes. There is a new dispute resolution system in the Industrial Relations Commission. We don't know what that's going to look like yet because we don't have the regulations and the guidelines. And I would suggest that we also need a practice direction from the Industrial Relations Commission. And in fact, we probably need a division of the Industrial Relations Commission to be created and populated, which doesn't exist now. So that's probably going to happen in the next 6 months. So bear in mind, new timeframes, and there are significant consequences for non-compliance. The first thing I want to alert you to on this category of claim, by the way, if you want, the slides will be given to you. So feel free to take photos, but the slides will come to you after today. With this type of claim, the insurer is obliged to determine the claim within 42 days, which is a very short time period compared to the provisional liability period of 12 weeks. So the pressure's on from the get-go. My thoughts on the 42-day time period are that, first of all, an insurer has to triage the claims to decide what category they fall into, whether it's the violence, trauma, criminality, or whether it's this conduct category. That is the first thing that has to be done. And it's not obvious at the beginning, and the story changes. So there is the prospect of a claim moving from one category to the other. Sometimes workers change their narratives over time, either on the basis of advice or otherwise. So we need processes to periodically vet and check how the psychological injury can be categorised. In making the claim, the guidelines, the CIRA Workers' Compensation Guidelines, Part 3.1, still contain the requirements of what is needed to ventilate a claim. We may see some change to that in the new guidelines. My friends at CIRA, and I do have friends at CIRA, even though I'm often criticising CIRA, but my friends at CIRA are currently working on the regulation and the guideline. This legislation talks about a claim being made. So in the past, it was sufficient for an injury to be notified by reference to a medical certificate, a certificate of capacity, a flimsy certificate of capacity, which contained no information often. We're going to need more than that. It talks about a claim, so I would anticipate a claim form. I've also heard murmurings that workers will be required to submit a statement, which is unheard of at this early stage. How that will be orchestrated is a bit beyond me, because there's a wide range of skill or lack of skill in the workforce, and sophistication when it comes to these things, or lack of. It will depend on how legal assistance is funded. I'm not sure that there's going to be a great deal of legal assistance available for this. So that's something that we need to keep our eye on. So 42 days is not a long time. My strong recommendation is talk to your investigators in the next 6 months to work out protocols that rapidly deliver statements from relevant witnesses. Forget about getting a covering report where the investigator summarises the statement. That's just their view of the evidence. Just get the statements. Get them done quickly. Now, disputing liability, Section 280, capital A, capital E of the 1998 Act sets out the requirements. There has to be a dispute notice under Section 78, so we know the rules around that now, but I expect there'll be more tinkering with those rules in the regulation or the guideline. The notice must be given to the worker no later than 42 days after the claim is made. The worker can seek a review of any aspect of the dispute. The review must be carried out, as we know, within 14 days. And there's a bit of a sting to the tail on this now. Failure to do so is an offence. So if you don't deal with your review within 14 days, it's an offence, and it carries a potential maximum penalty of $5,500. And if you make a review decision, that decision replaces the previous decision. So it needs to be articulated in full detail if it's a replacement decision. That thought just came to me then. It wasn't in my notes. A review request is also mandatory in order to start proceedings in the Industrial Relations Commission. So I just want to stress this category, it's going to be dealt with in the Industrial Relations Commission, not the Personal Injury Commission, okay? And guidelines can be made dealing with how these disputes are articulated and notified. So let's move to the Industrial Relations Commission. So for psychological injury claims involving bullying, etc., the worker must go to the IRC. The IRC, now we don't have a practice note on this yet from the IRC, but if we look at what the IRC does when dealing with employment claims involving the state government or local government, which is the jurisdiction of the IRC, the current jurisdiction, when those claims are dealt with, there's usually a conciliation process. And if the matter is not able to be resolved, it then goes to a hearing process. There are statements, written statements. Witnesses actually have to give evidence, both the complainant, the worker, and the witnesses who address the worker's story, and they can all be cross-examined. That doesn't really happen in the Personal Injury Commission. My thinking is it's more going to be like a traditional court process, and it's going to be dealt with based on evidence. I've said in the past, half jokingly, that, you know, sometimes in the Personal Injury Commission, you feel like things are more dealt with based on vibe. I don't think that's going to happen in the Industrial Relations Commission. So just sort of bear that in mind. Importantly, once the Industrial Relations Commission deals with it, there's going to be an outcome. So if the relevant conduct, bullying, excessive work, sexual or racial harassment, if that is not established, that's the end of the claim. It's finished. If, however, the relevant conduct is established, the IRC must issue a decision, a determination, and several things flow from that. Before I move on to the things that flow from that, there can be appeals as well. So under the Industrial Relations Act, Chapter 4, Part 7, there's an appeal mechanism. Query whether that will extend to this new jurisdiction. I don't see why not. So once a decision is made, that decision must be given to the insurer. And within 7 days, and so the decision is only about the conduct. Once the insurer gets it, within 7 days, the insurer must then decide whether or not to pay the compensation. And that's when the medical issues have to be dealt with. So I would envisage that there is still the prospect of a dispute on issues such as incapacity and need for medical treatment at that point. Where does that dispute go? Not the IRC, the Personal Injury Commission. So you can see how radical these changes are. I've never seen a split system like this or the like of it. Now, let's talk about entitlements, provisional liability. Provisional liability doesn't apply to these sorts of claims, but there is an obligation, which I have described in the slide as a pseudo provisional liability. It's actually called an interim entitlement payment. And what that says is, if the worker is totally unfit, the interim weekly compensation entitlement payment is 75% of pre-injury average weekly earnings. PRWE is the parlance in the industry. If the worker has a capacity for work, it's 75% less their ability to earn, or less their actual earnings or ability to earn, whichever is the higher. We all know that. And it caps out at the statutory ceiling, which is the Section 34 rate, with about $2,500 now, I think it is. And the worker can also receive up to $7,500 in medical expenses, or a different amount if it's prescribed by guidelines or regulation. The interim entitlement weekly payment and medical expense ceases if the insurer decides to dispute liability within that 42-day period, but there's a 14-day notice period before the payments stop, the weekly payments stop. The interim entitlement payment ceases 56 days after the claim is made in any event. So that's the maximum of the interim entitlement period. If the insurer decides to accept the claim within that 42-day period, there has to be an adjustment because they're only getting paid 75% of PRE. Now, I think I saw Tonya in here. Hi, Tonya. We had a discussion about this about 3 months ago, and it's a movable feast. In the Amendment Act, the adjustment was between 75% and 100% of PRE. Remember when we discussed that? Well, there's a sneaky little section in the Modernisation Act, which I just happened on at about 11 o'clock last night, that has changed that. It's the adjustment between 75% and what the worker would have been entitled to under Section 36 in the first 13 weeks. So it's between 75% and 95%. So you've got to watch this stuff like a hawk because you're going to get caught out. Presumably, once liability is accepted, normal transmission resumes. So Section 36, whatever's left of that, and then Section 37. And they're the provisions that deal with the benefits. There's also a couple of little stingers in here. The insurer is required to commence weekly payments as soon as practicable, but no later than 7 days after a decision is made or deemed to have been made to accept the claim. Moreover, the back payment has to be made no later than 21 days after the acceptance of the claim. A couple of offences just to, keep you stressed out or tense. It's an offence to fail to commence weekly payments within the prescribed timeframes, up to $5,500. This is a good one. It's an offence to refer a matter that a person knows, to refer for dispute, that the person knows is not a genuine dispute for the purpose of delaying without good cause the commencement of weekly payments. Think about that. Yeah. In other words, soft dispute notices, as we talk about in the industry, or delaying dispute notices leading to proceedings either in the IRC or the PIC could land you in trouble, up to $5,500 fine. Now, this is probably the fun bit of my talk. Yeah, what I found fun anyway, looking into the crystal ball in terms of what might happen. Maddie talked about how Section 11A might operate in practice or not. I think there's a real question about whether Section 11A has any work to do. It's not going to be relevant in the violence, trauma, criminality claim. It'll never be relevant for that. The potential relevance of it is in the conduct claims before the IRC, not the PIC. But if the PIC decides that the relevant conduct didn't occur, no bullying, no excessive work, no sexual or racial harassment, that's the end of the story. Doesn't arise for consideration. And if the IRC finds, alternatively, that the conduct did occur, how can there ever be reasonable management action? But in dealing with the matter before the IRC, the employer is allowed to present its narrative of reasonable management action in combating the alleged bullying, if you like. So they can present it, right? And that might contribute to a determination that there was no bullying, for instance, but there won't be a finding that 11A is made out. I can't see it. We'll have to wait and see what happens in practice. I also want to alert you to another jurisdiction of the IRC that is not a workers' compensation jurisdiction that will be relevant to what we do in Compo World. It's like Wayne's World, but it's not always excellent. So in the IRC, there's a stop bullying and a stop sexual harassment jurisdiction. Workers can make claims of that nature, and the employer must respond to those claims. And there is the potential for damages of up to $100,000 to be recovered by the worker who succeeds with a stop bullying claim. That's already there. I'm not aware of any cases. Maybe one of my colleagues in Workplace might be able to shed some more light on that. But the question arises as to whether there's going to be the potential for double dipping there. And there is potential for double dipping, I'll have you know. There's a section 280 capital A, capital J of the 1998 Act that has been introduced. And basically that says if a worker on a bullying injury has liability accepted and is receiving compensation for that bullying injury, workers' compensation, they can go to the IRC for a stop bullying order, but they can't recover damages. So let's just think about that. Let's just pause for a moment. What are applicant and plaintiff lawyers going to do? If I was advising them, I'd say, go to the stop bullying jurisdiction, run that claim, grab whatever you can of the 100,000 on offer, and then make your workers' comp claim. So this 280 AJ, in my opinion, if I was drafting it, it would be different. It would deal with the flip side. It doesn't do that. They should get people who know about this to write some of this stuff. All right, just want to talk a bit about medical evidence. So in the IRC, for the conduct type disputes, it's all about the conduct. I don't really see the IRC looking at the injury, the psychopathology, if you like. They may look at the history. I would recommend insurers continue to obtain clinical records and reports from treating doctors. I doubt you will be able to obtain IMEs within 42 days unless you have excellent arrangements with your medico-legal providers. I mean, have a crack by all means, but it's going to be hard. I don't think the IME is vital to dealing with the IRC piece because it's looking at conduct. But the clinical material from treating doctors is really important because that clinical material may expose the complaints that the worker makes along the way, including non-work issues that might be troubling the worker. And that's important because when making submissions against the bullying to challenge the alleged conduct, you can make the submission, well, there was no complaint about that in the clinical records. It only appeared when the worker went to a lawyer. So the clinical records are still very important. A question in my mind is, how far will the IRC go in examining whether there's an injury? That is a mental or psychiatric disorder causing behavioural, cognitive or psychological dysfunction. I think that's the domain of the Personal Injury Commission after the conduct has been established. Who pays for the IRC in all of this? There's a section in there that says the Workers' Compensation Operational Fund does, which means premiums. Legal costs, workers' legal costs. Who's going to pay for workers' legal costs? Probably ILARs, but I'm not sure about that. It's another one of the emerging issues. Will the employer be entitled to legal representation? Interesting question. At the moment, in the Personal Injury Commission, if a worker is not legally represented so that they run their own case, there is no entitlement for the respondent, the employer, to be legally represented, but you can obtain leave. And that's what we've done recently in a series of cases that we've had where there are unrepresented applicants. Legal costs for employers. I'm told Schedule 6 is being looked at. But if the process is a serious litigious process, not based on vibe, where it requires heavy duty legal analysis, I just wonder whether the Schedule 6 rates, the traditional Schedule 6 rates, will cut the mustard with most lawyers. I doubt it. So those are my crystal ball observations on what it might look like. I could be wrong about some of that or a lot of it, but I'm prepared to put myself out there on those points. Other than that, we've left about 10 minutes for questions. And before we go into questions, I just foreshadow some of the things that might come up in our ensuing sessions beyond today. We have to talk about permanent impairment. That's going to be a nightmare. Single assessment of permanent impairment. I'll just put that out there for you to think about. Medical expenses, new test, reasonable and necessary, not reasonably necessary. Commutation, back on the agenda. Now, I've had some self-insurers speak to me about the IRC piece, and they've canvassed with me whether we can use the IRC proceedings as a vehicle for a wrap-up settlement. I think so, maybe. They certainly want to be looking at it. What the other parts of the system does about that, that's a matter of policy. So insurers will need to come to a policy position on all of this. There's other things in the legislation. There's other changes relating to death benefits and compromising claims. And there'll be more from the regulations and the guidelines. After today, the presentation will be emailed. As usual, we ask for feedback. But what I really want to ask everyone to do is, having heard what we have said today, is there anything that you'd like us to expand on? And there will be things to expand on. So if you have issues that you want more detail on, tell us and we'll do it. And if you've got large organisations and you would like a Bardia Perry team member to come and talk to your people about it on certain aspects of this, feel free to ask and we'll probably do it. So that's all we've got to say today. Come with us on the rest of it and let's have a bit of fun. Happy to take questions. We've got a few minutes and we've got a microphone. And have we got any on the chat? Okay. Well, we'll go on the chat first. Yeah. Maddie, do you want to come up?
The first one is, what do you postulate or hypothesize is an example of a real and direct connection to employment and what might not be?
Okay, I'll take it. All right, so you've got to look at the injury in context. So if you've got clinical material that exposes the potential involvement of non-work causes, financial problems, substance abuse, prior history of mental illness, that will inform the impact of the work events on the mental state, and that may enable you to argue that there is not a real and direct cause. Maybe.
The next one is for the objective test, only to the extent the worker's perception of the event is reasonable. Is there or will there be any guidance on how we are to deduce what is reasonable from one person to another, particularly when these claimants are claiming psychological injuries and many of them have pre-existing psychological issues now or in the past, or different life experiences that create their eggshell psyche or their ability to decide what is reasonable or not for themselves? It doesn't seem objective at all.
There's lots to say about that.
There is a lot to say. I think that's a fair question. I think in terms of reasonableness, it's always, it comes down to how the Commission interprets it. And I think with these new provisions, we might see not necessarily a step away from the Attorney General's Department and K, which talks about, the different principles on perception. Might not necessarily move away from that and disregard it entirely. But I think when we're bringing into the second part of the test requires, an objectivity, maybe we'll see a bit of an expansion in the Commission. But I think at the end of the day, it will come down to how the Commission deals with it. And that might be where we see a bit of guidance come out rather than...
Do you want to know what I really think? It's ridiculous. It's ridiculous to have an objective test that brings in perception. I have spoken to someone in the know about this, and there was a big debate about it. My understanding is that it was meant to be an entirely objective test, and the debate was lost. So what I say about that, I'll come back to you, sir. What I say about that is that it's an attempt to wind back the perception argument that, or the perception principle that arose out of Chandler's case, Court of Appeal case, which was then expanded upon in Attorney General and K, which set out all the principles in summary form. They're trying to wind that back because everyone thought it was ridiculous in the real world when there were certain concrete events that happened that caused the injury, and then all of a sudden fantasy could take over. So I think the argument's going to be on the objective evidence and determining the issue by reference to the objective evidence, but it's not completely cancelled.
And there is a note which was added in the most recent, changes, which, if I'm recalling correctly, talks about kind of looking at it from would a reasonable person in those circumstances find themselves that they were being the subject of bullying, harassment, that sort of thing. So we might see, more of an approach that's adopted outside of workers' comp of a reasonable person in those circumstances rather than necessarily their perception overriding what might be seen as common sense.
We have a question.
We'll go to a couple in the room.
Just have the microphone too, so the audience, the remote audience, can hear you.
I was going to ask in regards to that. I assume you'll be providing initial advice in that liability determination phase before it gets to the Commission. Have you had any thoughts on how
if our clients kindly instruct us?
Have you got any thoughts on how you're going to approach it? Would you be relying on, the employer's evidence around their policies and performance management processes? And is that the approach you would take?
I think if we're coming at it from, we're not in the Commission, there may not be any test cases for a while. When you're looking at, I guess the part of it to remember is that the perception's relevant, but only to the extent that it's reasonable. So I think I'd be approaching it from the sense that, well, okay, they may have a different perception, but if we're looking at reasonable and we're trying to adopt or figure out what reasonableness means, well, also those test cases are coming. I think that's the framework in which we'd be looking at it, but may have some other thoughts on that.
I agree with that.
And so I've got the microphone. Just another question around
Yeah, sure.
the practical challenges for making a liability determination that shortened time frame and the challenges of getting an IME. Would you be advising employees to take a different path around, I guess, determining or making an initial liability dispute on a, I guess, performance or conduct related matter when you can't cover off the medical side of things, making it wholly predominantly related?
I call me old-fashioned, but I always thought that the onus is on the worker to prove the injury. What has developed is a practice of employers and insurers having to assemble evidence to disprove an injury. So you've got to deal with what is before you, what has been submitted, and does that satisfy the eligibility requirements in the legislation? And if it doesn't, it would, in my view, it is open to you to dispute liability.
So hopefully insurers will be confident enough to issue disputes without an IME, or at least an interim dispute.
Yeah. We'll know more after the guidelines and the regulation, I think, but that's my basic sort of response at this stage of the game. Are there any more questions from home? Oh, there's one here.
Somewhat related to that, and it's sort of twofold. I was going to ask if there's any around the definition of the psychological injury, if there's going to be any onus to use the DSM-5, for example, or for diagnoses to come from a psychiatrist. And then will Section 71 come into play in that 7-day time period for insurers to say, well, you haven't provided the evidence, you need to provide this before you can take our dispute to the Commission?
Taking the last point first, you've got to make a decision. So if the evidence hasn't been provided, you make a decision. And
So
then,
will the
and then there's got to be a review, and then you can go to the IRC.
Oh, so sorry. If it comes, here's the hypothetical example. It goes to the IRC. They say that it was a relevant event.
Okay.
But we don't have a DSM-5 diagnosis. And we say, well, actually, you haven't provided evidence of an injury. And so you need to provide this evidence. And until you do, you can't go to the Commission to challenge our dispute.
That's when the insurer has to make its decision within 7 days of the IRC.
Exactly. And that's coming into going, well, we only have 7 days. You're not engaging. You're obliged to engage. Can we rely more on that in that circumstance?
I think you can, but it'll come down to the policy of the insurer in terms of how they deal with these things. I can envisage self-insurers taking a hard line on that.
Jumping back to the DSM-5 part. So the old definition that we had, just to, I guess, rehash to preface my explanation, was that a psychological injury was a psychological psychiatric disorder which extended to include the physiological effect on the nervous system. The new one says mental or psychiatric disorder. Now, at first glance, that may seem, yes, it has to be DSM-5, but the interpretation of the old section, which also uses the term disorder, doesn't actually require the DSM-5 diagnosis to be precise. Case law generally finds, well, diagnoses can fluctuate as long as you find the effect on the physiological system, or in this case, it will be behavioural, cognitive, or psychological dysfunction. I think it might be satisfied. So it will be different, but I'm not hopeful that it will be that different.
Yeah. Just flag one other thing on determining an injury. For permanent impairment, we're stuck with the PIRS criteria. I gave evidence to the parliamentary inquiry in July, and one of the points I made was that it is easy to present yourself in such a way at an assessment to maximise the ratings under the PIRS criteria. That was actually quoted in the report, and it's seen the light of day in the Modernisation Act because the chief psychiatrist of New South Wales has been tasked with reviewing PIRS criteria and looking at the efficacy of that as a way of determining permanent impairment and looking at alternatives, and they have to report back to Parliament within 18 months on that. So that's a really interesting piece. We're slightly over time. I'd just like to take one more from the remote people, if there is another one.
Yeah, we've got quite a few, so you might have to review some of those afterwards. But one of them was, what happens if the worker does not supply the IRC outcome in 7 days?
Presumably, the insurer will be involved in the IRC proceedings, and presumably the insurer will have the decision as soon as it's issued. So I don't really see that's an issue, and it's not the sort of point that I would encourage an insurer to take to delay. If you've got it, deal with it. Shall we do one more?
Yeah, sure. One more. Okay, after 42 days, if we accept a sexual racial harassment claim and we are obliged to back pay adjustment within 21 days, how would this interact with the SOP 27, whereby we need to obtain a Centrelink clearance prior? If we don't receive it within 21 days, are insurers committing an offence, or do you think we will see amendments to this instrument from CIRA?
I'm happy. I'm not happy, but I can say I don't know the answer to that. It's an excellent question. Obviously, the author of the question is someone who pays close attention to these things. I suspect that may be something that is dealt with in guidelines, but it's not the first time where there are lacunas or gaps in the legislation or the system, and inconsistencies as well. So I think the Commonwealth legislation prevails. There has to be a Centrelink clearance, and I can't see an insurer getting in trouble for abiding by the Commonwealth legislation on that. Any final question in the room? We've gone 5 minutes over time, so I apologise for that. No final questions. We'll try to respond to the ones online later. Thank you very much for coming. Please come again. Please make suggestions on what you would like to talk about. It's a really exciting time. I can't tell you how excited I am about it.